The electoral code of conduct is a very important instrument that is there to assist in terms of regulating the relationship and the conduct by political parties in an election. So the contravention thereof, it's a very serious matter. So when you talk about having to ensure that you've got free and fair elections, the code of conduct plays an important role in terms of creating environment conducive to free and fair elections. And therefore, its contravention is seen in a very serious light. Now, when you look at the law, you will find that the Electoral Commission has got two instruments in law that empower the Commission to be able to take action against those who contravene the law. The first section is Section 95, subsection 2 of the Electoral Act. This basically says that if the Commission has an interest in the matter, the Chief Electoral Officer can refer that matter to the Electoral Court in order for the Electoral Court to deal with whatever contravention that would have occurred. But the second instrument that the Commission can use is Section 103A, which basically implores the Commission to explore possibilities of using conciliation to deal with any matter that leads to a complaint or contravention of the Electoral Act. So the Commission would then therefore get the parties' consent and try to deal with the issues amicably. Now, if a political party or a candidate contravenes the electoral code of conduct, there are certain possibilities. The first one is that depending on the nature of the contravention, a party can actually be fined or a candidate can actually be imprisoned for a period of 5 years. Certain contraventions, of course, they are actually even stiffer in the sense that a candidate can actually serve for a period of 10 years for contravening the Electoral Code of Conduct. So it is important for elections and for political parties to make sure that they adhere to the rules, particularly the provisions as contained within the Code of Conduct. Or ahead of the 2016 local government elections, a member of the EFF said things that were in contravention of the Code of Conduct, and then that person was actually held before the Electoral Court, and in fact, even the party itself dissociated itself from the statement of that person, and the Electoral Court actually disqualified that person from being a candidate for those elections. Well, contraventions of the Electoral Code of Conduct, it's a matter that is dealt with by the Electoral Court. So Electoral Court will look as to whether a particular candidate or a leader of a party was doing whatever he or she was doing as a result of carrying out the responsibility for a political party. And in fact, if the Electoral Court can come to a determination that an official of a political party was doing certain things as an official of that political party, that party runs a risk of actually being disqualified or its deposit being taken. And therefore, if the deposit is taken, it means that that party will not actually be participating in the election. So there are very severe measures that are in place that can actually be invoked in order to deal with contravention of the code by a political party or an office bearer of a political party. It happens all the time. I mean, the political parties, if they are grieved, by actions of another, they have an avenue of taking matters to the electoral court. And therefore, the matter that the Freedom Front Plus is engaged in now, where it is taking a BLF to the electoral court, is not unusual. So on a matter like this, I do not expect the electoral court to spend more than 5 days before making a determination on this particular issue. They are quite aware that the issues relating to the elections have got to be dealt with speedily because they've got implications for all sorts of things that are happening in the electoral processes. If the party is disqualified, then it would mean that certain measures must be taken to make sure that that particular party is not in a ballot paper. And the ballot papers have already been produced. So the commission would have a very difficult task of having to make sure that they put in some kind of measures to make sure that that particular party does not participate in an election. Ordinarily, when the people are aggrieved by the decision of the electoral court, they still have the constitutional court as a court of last instance. So take, for instance, the issues that related to clockware and the matter of addresses or lack of addresses in the voters' roll. That matter was taken firstly to the electoral court, and the electoral court made a determination. And then after that determination, the matter was taken to the constitutional court for a final decision. And once the constitutional court has taken a final decision, no one can appeal the decision of the constitutional court. Yeah, if the constitutional court takes a decision, rather the electoral court takes a decision, and that decision is appealed, it basically means that it is going to be, things are going to be running as before the judgment by the electoral court. And of course, if then the elections take place before the constitutional court can hear the matter, it would mean that a party that is supposed to be disqualified will be in the ballot paper, but then a decision would have to be taken in terms of the votes cast for that particular party after the decisions have been made by the Constitutional Court.